Welcome to The Explainer. Today we're going to dive into the really complex topic of divorce, or talaq, under Muslim personal law in India. Now, this is a system that has super deep ancient roots, but it's also one that's constantly changing. We're going to look at all the different ways a marriage can be dissolved, who actually has the power to kick things off, and where the modern legal system comes into play.
But hey, before we get into the nuts and bolts of divorce, let's start with something at the very heart of the Muslim marriage contract itself, the dower, or mehar. This is a required payment or gift from the husband. So here's the question. Who does it actually belong to? Is it for the wife to keep, or is it for her family? Just hang on to that thought, because the answer tells you a lot about a woman's financial independence in the marriage. And trust me, it's going to pop up again later. All right, here's our game plan. We'll kick off with the basics. Then we'll look at divorces started by the husband, then the wife's right to do the same. After that, we'll talk about options for splitting up mutually, and finally, how the Indian courts can step in. Okay, so first things first. Under Muslim law, divorce isn't just one single process. The biggest difference you need to get your head around is whether the divorce happens outside the courts, based on personal law, or if it needs a formal court to get involved.
So on one hand, you've got what's called extrajudicial divorce. This is all the methods that are part of Muslim personal law that don't need a judge. And on the other hand, you have judicial divorce, which is when a court grants the divorce based on Indian law. We're going to spend most of our time on those extrajudicial methods because they're really the traditional foundation of the whole system.
So let's jump into the category that gets talked about the most. Divorce started by the husband. You know, there's way more to it than what you see in the headlines, so let's break down the traditional ways it's done. The most approved and traditional form is called Talaq al-Sunnat, which basically means divorce the way the Prophet's traditions outlined. And the whole point here isn't about being fast. It's actually the opposite. The process is designed to be really thoughtful and to build in chances for reconciliation before the marriage is over for good. It comes in two main flavors.
First up is Talaq Asan, which is seen as the best or most proper way. Here the husband makes just a single declaration of divorce. What that does is it starts a 90-day clock, a waiting period called Biddat. If the couple gets back together at any point during those 3 months, the divorce is just canceled. It's a really powerful, built-in cooling-off period.
The second approved form is Talaq Hasan, or the good form. Now this one is a bit more drawn out. The husband makes 3 separate statements spaced out over 3 months. And crucially, each of these declarations has to be made during a specific time, when the wife is in a period of purity known as tuhar. The divorce only becomes final and irreversible after that third and final pronouncement. So just to put them side by side, Asan is one single statement that starts a 90-day window for reconciliation. Hasan spaces it out over 3 months, with 3 different chances to change your mind before that final third declaration. The common thread here is really clear. Both of these approved traditional forms are built to prevent rash decisions and to make sure people think things through. And this, of course, brings us to the most controversial form, the one you've absolutely heard of, instant triple talaq, also known as talaq ul Biddat. This is the practice where a husband could just say talaq, 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 all in one go, whether in person, on the phone, even in a text message, and boof, the marriage was considered instantly and irreversibly over. And here is the single most important takeaway. In India, this practice is now illegal, flat out. After years and years of legal battles led by Muslim women, the Supreme Court declared instant triple talaq unconstitutional, saying it violated the fundamental rights of women.
The big turning point was this landmark 2017 case, Shayara Bano versus the Union of India. This judgment wasn't just about helping one person. It was a total game changer. It fundamentally changed the landscape of Muslim personal law in India and strengthened legal protections for millions of women.
Now, besides the different kinds of talaq, there are 2 other, less common ways a husband's actions can lead to divorce. One is ila. This is where he takes an oath to stay away from his wife for 4 months. If he does that, she then gets the right to go to court for a divorce. The other is zihar, which is basically a type of insult, where a husband compares his wife to his mother. This is considered so out of line that it also gives the wife the right to seek a divorce from the court. Okay, so let's flip the script here, because we need to tackle a huge misconception that only men can initiate a divorce. That is just not true. Muslim law actually has several really powerful ways for a wife to end her marriage. The first one is called talaqi tafwiz, or delegated divorce. And this one is actually pretty fascinating. It allows the husband to delegate his own right of divorce to his wife. It's like he hands over the keys, so to speak. This can be written into the original marriage contract, the nikah, or agreed on any time later.
And this power can be absolute, or it could be tied to a specific condition. Like say, if you were to take a second wife, it could give her an automatic way out.
Next up is li'an. This is a really strong legal protection for a woman's honor. If a husband accuses his wife of adultery, but he has no proof, she has the right to file for divorce simply on the grounds of that false accusation. If the court finds the charge is baseless, they'll dissolve the marriage.
So, we've talked about divorces started by the husband and by the wife. But what happens if both people agree it's just not working out? Well, Muslim law has provisions for that too, with methods that are all about agreement instead of conflict. The first method here is khula. In this case, the wife is the one who wants the divorce, but the husband has to agree. To get his consent, she offers some kind of compensation to be released from the marriage contract. And very often, that compensation is her dower, that gift she got when they got married. She's essentially returning it to buy her own freedom.
And then there's mubarat, which is, the most straightforward kind of mutual divorce. The word itself literally means mutual release. It happens when both the husband and wife are just in total agreement that the marriage is broken. Either one of them can suggest it, and once the other accepts, the divorce is done.
So, finally, what happens when none of these other options are on the table? This is where the formal Indian legal system gets involved, through a really important law designed for exactly this situation. The Dissolution of Muslim Marriages Act of 1939 was a huge deal. It was a landmark law that specifically gave Muslim women 9 concrete, legal reasons to go to court and ask for a divorce. And these grounds cover a whole range of serious issues, like if the husband disappears, if he fails to provide financial support, if there's cruelty, or even if he's in prison for a long time.
And get this, some of the details in this act are really powerful. For instance, if a husband fails to provide maintenance for his wife for just 2 years, that's it. That's enough for her to be granted a divorce by the court. This law was an absolutely critical step in spelling out and strengthening the legal rights of Muslim women in India.
So let's pull this all together for a second. This table gives you a great snapshot of all the different options, from the traditional husband-led Talaq Sunnat to the wife-led delegated divorce to the mutual agreements of khula and mubarat, and finally, the intervention of the courts. And hey, remember that first question about the dower? Well, the answer is, it belongs completely to the wife. And that's not just a tiny detail, it's the whole basis of her financial power, giving her something to bargain with to get her freedom in a khula divorce.
And that really brings us to our final thought for today. What we've seen is a legal system that's part ancient tradition and part modern law. And the recent ban on instant triple talaq proves that this system is not stuck in the past. So the real question we're left with is, how will this tug of war between personal law and constitutional rights continue to shape the lives and choices of millions as Indian society itself keeps changing?